Protesters make their arguments outside the Missouri Court of Appeals. Inside, lawyers make theirs. As former Kansas City Police Detective Eric DeValconeer appeals his involuntary manslaughter conviction in the death of Cameron Lamb. In a twist, the Missouri Attorney General's office sides with DeValconeer, seeking to vacate his conviction.
But today, DeValconeer's attorney and a deputy attorney general got a grilling in the courtroom from a panel of judges skeptical of some of their arguments. Fox 4's Jacob Kittelstadt joins us. He's live from the Court of Appeals downtown. Jake, give us some context on the panel's pushback.
Well, what you have to remember here is that DeValconeer was found guilty in what's known as a bench trial. That means it wasn't a jury that found him guilty. It was actually a judge, and that was a choice that was made by DeValconeer's defense team. So now what you have here is the Court of Appeals judges looking not only at that ruling, but also the specific legal justifications that he used to come to that decision. And a lot of the questions here are based on that document.
Their presence violated the Fourth Amendment.
With the original prosecuting team out of Jackson County in the courtroom, they are the third party advocating for DeValconeer's conviction to be upheld, addressing rehashed arguments about what led to Cameron Lamb's shooting death on College Avenue in December of 2019.
Appellant now contends that the hot pursuit exception justified his presence in Cameron's home. He makes that argument despite the trial court's explicit finding that there was no pursuit, fresh, hot, or otherwise.
That's clearly erroneous because we have videotape, if you'll go to Exhibit 80, showing several traffic crimes.
Jonathan Lawrence, attorney for DeValconeer, focused on police tracking Lamb before the shooting, but faced extended questioning from Judge Thomas Chapman.
But if the Curleys on private property, they have to have probable cause to make an arrest. True. And they acknowledge they didn't have probable cause. Both of these officers did.
The subjective conclusion of the officer whether or not they have probable cause is irrelevant. It's an objective standard.
So you're saying they had probable cause to enter the premises and with their guns drawn to arrest this man for traffic violation?
For 13 separate traffic violations.
The Attorney General's office, stepping into their defense of DeValconeer, leaned on self-defense arguments, adding that under Missouri law, resisting arrest is illegal even if the arrest is unlawful.
And they are not an initial aggressor merely by virtue of the fact that they are armed police officers and that they are prepared, if necessary, to use force.
Whether or not he was doing the right thing, it's hard to defend his fellow officer, is different from whether or not he was justified in using deadly force. Wouldn't you agree?
So there's not a great timeline on when the Court of Appeals will come down on their decision. It often takes weeks, John.